Remember when I began talking, I mentioned that there would be a lot of distinctions today. Well, one of the distinctions that we really need to make is the difference between common law and Roman law. Because if you're going to have an appreciation of canon law, you have to start by being aware that your understanding of law as an American is based in common law, while canon law is rooted in Roman law. So let's talk a little bit about the difference between canon law and Roman law. Another problem Americans have in appreciating canon law is the fact that our legal system has its historic roots in common law, and the code is rooted in Roman law. The laws of most countries are based on one of two great systems of law, Roman law or common law. However, beware of possible confusion resulting from different applications of the same term. For example, in countries where Roman law is followed, they do not call it Roman law, they call it civil law. On the other hand, in lands where common law is practiced, the term civil law is used to distinguish it from criminal law and administrative law. So, for our purposes today, I'm going to stick with the original terminology and refer to Roman law and common law. So what's the difference? One is adversarial, the other is inquisitorial. One is presidential, while the other is strictly code. One seeks consistent form, the other seeks the ideal. In common law, as experienced in the United States, ideally a judge impartially enforces procedural law, and two lawyers argue their case, each construing the facts in a way that most favorably applies for their client. Primarily, a jury or a single judge makes a decision. Arguments are based on the authority of previously adjudicated case law. In other words, how other similar matters were resolved becomes binding on lower courts and forms a type of law in and of itself. Roman law is basically a code-based legal system. How other cases were decided before are not controlling. Roman law seeks to expose the truth of any given conflict and then applying the law to those facts. Because the search for truth is considered more important than a strict adherence to procedure, the way a case proceeds is less important than getting to the truth. In Roman law, there is normally a tribunal of judges who consider the case. Ironically, Roman law, as experienced in ancient Rome, initially began as a precedent system, but resulted in confusion and contrary case law as time went on. Since different results emerged from similar cases, no one knew for certain what the law was, so they didn't know what was expected or even what to avoid. Very similar to the situation we face today with administrative law. Not knowing what the law expected from citizens weakened the concept of law and consequently the whole society. So later, emperors began to switch from precedent-based legal systems to a code-based system. By 529, under the Eastern Roman Emperor Justinian I, the Corpus Juris Civilis, the body of law, was completed. This was a combining of all the previous codes and virtually legislated almost every conceivable detail of social life. Norms for behavior were clearly spelled out, and so were the penalties one would face if they were found guilty of deviating from the law. It was so well received that it became the law of Western civilization. In the early 19th century, Napoleon Bonaparte revised and modernized the corpus, and it became the model of law for Europe and around the world, except for England. England, for whatever reason, decided to stick with the older system of precedent law. So wherever the British Empire extended, they brought with them their legal system. That's why the USA, Canada, Australia follow common law systems, except Louisiana in America and Quebec in Canada that follow more Roman law system. Judges in the United States need to go to law school, but after law school, either by appointment or by election, they become judges. Ostensibly, the very best rise to the top positions as judges, but unfortunately, that's not always true. In Roman law, judges are trained to be judges and often sit on tribunals, that is, 3 or more judges. Common law judges sit alone until a case gets to the appellate level. They know procedure well and make most of their decisions about whether an attorney has properly followed the procedure. A judge's decision can and is often overturned because a higher court held the lower court failed to adhere to the procedure. For example, it could be absolutely clear that an individual committed a murder, but in a common law court, that murderer could be found not guilty because the arresting officer or the lower court judge failed to follow the proper procedures. That would not be the same result in Roman law court. In common law courts, procedure is more important than the truth. The innocent can be convicted on procedural issues, and more often, the guilty are acquitted over procedural irregularities. Roman law judges know what the law is and seek through probing questions they themselves pose to determine how the facts before them fit the law. In that sense, Roman law can be said to be inquisitorial. While they apply the law strictly, they are also looking for the intent of the legislator in making the law. So they are trying to find a solution that not only attends to the law, but the reasons behind the law. This often gives them freedom to find creative solutions. While they will give serious consideration to earlier rulings, they are not bound to follow precedent, especially if they determine that to do so would result in justice denied. For example, in a criminal case in common law, a court will find the accused to be guilty or not guilty, a black and white result. In Roman law, there might be a third option, not proven. Such a court would argue that many criminals escape punishment simply because they have a good lawyer, or the police have been incompetent, or a witness has lied, etc. And to grant a full formal legal acquittal to such a person would taint all verdicts and expose the truly innocent to the suspicion of merely having been lucky. Another way of describing this is that common law draws from the abstract rules from specific cases, where Roman law starts with abstract rules which judges then apply to the various cases before them. Canon law is based on Roman law, so the way it approaches the resolution of a legal conflict is different from the way we are accustomed being formed in the context of common law. Take, for example, canon law's approach to marriage cases. The issue before each case is whether a valid contract of marriage existed at the time of consent. A decision in each marriage case will consist of 3 parts: the law, that is, what the code tells us about marriage; 2, the individual facts from the specific case before the court; 3, reconciliation of the first 2. If the facts match the law, then the marriage is deemed valid. If not, then the marriage is deemed invalid. In order to function, the tribunal must follow procedural laws laid out in the code. But routinely, the judge will exempt or expand those procedures in order to get at the truth of the situation. To protect from the bias or incompetency of each case is automatically appealed to a 3-member tribunal outside the influence of the local tribunal. At this point, I would ask if there are any questions. But, it doesn't really matter if I'm there or not, because whenever I would ask, are there any questions, and questions would come, and I would start to answer the questions, Father Place would interrupt and replace my answer with his answer. So now, if there are any questions, please direct them to Father Place.